I want to start with a number. 67. That's the age my father was when he died. He had a plan for his house. He told my mother exactly what he wanted. And when he was gone, do you know what actually happened? Nothing went the way he imagined. My name is Carol Ann Mitchell. I spent 24 years as a retirement and estate planning attorney right here in Scottsdale, Arizona. I helped over 600 families navigate the most complicated decisions of their lives. That intersection of money, time, family, and legacy. I retired 8 months ago at 65 years old. And I want to tell you something I told nearly every person who sat across from me in my office. The most dangerous thing most people do with their home is the thing that feels most obvious, most loving, most simple. Leaving it to their kids. Now wait, don't turn this off yet. I am not here to tell you not to leave your home to your children. Of course you should, if that's what you want. I'm here to tell you that how most people try to do it is where things go catastrophically wrong. And I've watched it happen. Families torn apart over a house. Adult children who stopped speaking to each other. Estates that owed tens of thousands in taxes that could have been completely avoided. Homes meant to be gifts turned into legal nightmares that dragged on for years. This is not a small thing. For most of us, our home is the single most valuable asset we own. And it deserves to be handled with the same care we put into everything else. So stay with me on this. Before this is over, you're going to understand not just what the mistakes are, but what to do instead. And as I always say, this is educational content, not legal advice specific to your situation. Please work with an estate planning attorney who knows your circumstances and your state's laws. But what I can give you today is the framework, the questions to ask, the traps to watch for. All right, let's talk about your house. I remember when I first started practicing, back in 1999, one of the first things that struck me was how often clients came in feeling like they had already solved the house problem. They'd put a child's name on the deed, or they'd written a quick will that said the house goes to the kids. And they sat down across from me with this look of relief, like, "Okay, that's done. What's next?" I understand that feeling completely. I'm a mum. I'm a grandmother now, 3 grandchildren. Emma is 7, Noah is 5, and baby Olivia is 8 months old. And when I think about someday, I feel that same pull. The desire to make things easy for them, to spare them the paperwork and the chaos. But here's the thing about estate planning nobody tells you. Simple feeling decisions and legally sound decisions are not always the same thing. And the gap between them, when it comes to real estate, can cost your family an enormous amount of money, time, and peace. Let me tell you about Margaret. She came in around 2011, 71 years old, recently widowed, organized, practical. She set a manila folder on my desk and said, "Carol, I took care of the house 3 years ago. I put my daughter's name on the deed." And she said it with such confidence, such satisfaction, like she had been thoughtful and responsible. And I remember thinking, "Oh, Margaret," because I knew immediately what she had accidentally done, and it wasn't what she thought. Most people believe there are just 2 ways to handle a house when they think about what happens after they're gone. You put someone on the deed now, or you put it in your will. Both feel like plans, Both feel like you've taken care of something important. The problem is, most people have no idea what actually happens legally when they choose either of those paths, and the surprises are expensive. Let's start with the will, because that's where I hear the most confidence. I put it in my will. It goes to my kids. Done. I heard that in some variation, probably 1,000 times over my career. And every time I had to gently explain the same hard truth. A will does not avoid probate. I want you to really hear that. A will does not avoid probate. A will is technically a set of instructions to the probate court. It still has to be filed, processed, and validated. And that process is public, it takes time, and it costs money. In Arizona, a fairly straightforward probate on a $400,000 home can take 6 months to 2 years. Attorney fees are often set by statute at 3 to 5% of the gross estate value. That's $12,000 to $20,000 in legal fees on a home worth $400,000. And that's the uncomplicated version. If heirs disagree, if creditors make claims, if anyone challenges the will, add more time, more money, more heartache. This is the first illusion I need to break for you. The idea that having a will means your estate is handled. For real estate, a will on its own often means you've created instructions for a long, expensive legal process you were trying to avoid entirely. Now let me talk about the other common approach, the one that feels even cleverer. Adding your child's name to the deed while you're still alive. I call this the "I just made it simpler" strategy. And the people who do it are always trying to make things easier. But it creates problems most parents have never considered. When you add your child's name to your property deed, you've made a completed gift, with tax consequences most people never anticipated, never planned for, and frankly never knew about. Here's the capital gains story, and I need you to listen carefully because this one is significant. Let's say you bought your house in 1988 for $150,000. That is your cost basis. Today that house is worth $550,000. If you die with that house in your name, your children inherit it with a stepped-up basis. Their tax basis becomes the fair market value at the date of your death, $550,000. If they sell it for $550,000, they owe $0 in capital gains taxes. $0. The tax law wipes out all the gain you accumulated during your lifetime. But if you add your child to the deed today, you are transferring your original basis to them, $150,000. If they eventually sell for $550,000, they owe capital gains on $400,000 of gain. At 15 to 20% federal rate, that is $60,000 to $80,000 in taxes, on a gift you thought was generous and clean. Boy, did I see this play out, more times than I can count. A well-meaning parent trying to simplify things ends up costing their child tens of thousands of dollars because of a paperwork decision made without guidance. And that's not even the worst of it. When you add your child to the deed, their ownership interest is now exposed to their creditors. I had a client, I'll call him Robert, who put his son on the deed with the best intentions. 18 months later, his son went through a divorce. His daughter-in-law's attorney argued the son's share of Robert's home was a marital asset subject to division. Robert, still living in that house, found himself in a legal dispute over a home he'd owned for 30 years. We worked through it eventually, but the months of uncertainty, the legal fees, the stress of not knowing whether he might be forced to sell his own home, that was devastating. And entirely preventable. Now let me talk about something most people really don't know. And this is the one that haunts me most: Medicaid estate recovery. If you are approaching 65 or already past it, and there is any chance you might need long-term care, understand this. Roughly 70% of Americans over 65 will need some form of long-term care. Medicaid is means-tested, and your home is often exempt while you're alive. But after you die, in most states, Medicaid has the legal right to recover what it spent on your care from your estate. And your home, if it's still in your name, is part of your estate. I had a client I'll call Ruth, 78 years old, widowed, owned a modest Phoenix area home worth about $290,000, free and clear. She needed memory care for 3.5 years. Medicaid covered roughly $210,000 in costs. After she passed, the state filed a recovery claim against the estate. The house had to be sold. Her daughter received what was left after the state took their $210,000. Ruth had never known this was possible, never been told. And by the time her daughter came to me, there was nothing we could do. The planning window had closed. That is the hidden danger. Not just probate costs or capital gains, but the potential for the state to have a legal claim against your most valuable asset. Let me give you some numbers to anchor this reality. Average nursing home care in the United States runs about $95,000 a year for a semi-private room, over $108,000 for private. Average stay is about 2.5 years. That's a potential Medicaid exposure of $190,000 to $270,000 or more. On a $350,000 home, that is a very significant chunk of what you were hoping to pass on. And I want to talk about something that doesn't get discussed enough: the family conflict that comes from unclear inheritance plans. I've watched siblings stop speaking over a house. Not over millions of dollars, over a 3-bedroom home that Mum loved and nobody knew quite what to do with. I had clients, the Hendersons, 3 adult children, 1 house. Mum's will said split equally. What she didn't have was any plan for when one child wanted to sell, one wanted to keep it as a rental, and one wanted to move in. No mechanism to resolve that conflict. They spent 14 months in a dispute that nearly went to court. By the time it was resolved, 2 siblings hadn't spoken in over a year. One of them told me, "My mother's house was supposed to be her gift to us. Instead, it's the reason we don't have a family anymore." You see what I'm saying? The asset meant to carry love and legacy forward becomes the thing that breaks the family apart. And the cognitive piece matters too. We are talking about decisions most people make in their 60s and 70s. According to the Alzheimer's Association, about 1 in 9 people over 65 have Alzheimer's disease. Decisions made with diminishing cognitive capacity can be legally challenged, can be reversed, and can create complications that make everything worse. The window to plan clearly is not infinite. It has an end. And we often don't know where that end is until we've passed it. All right, here is what you can actually do. Because this conversation is not meant to scare you into paralysis. It is meant to move you toward action. The first tool is the Revocable Living Trust. In my professional opinion, this is the most comprehensive solution for homeowners who want to pass property to their children efficiently and cleanly. You create the trust during your lifetime. You transfer the title of your home into the trust. You remain the trustee, meaning you have complete control. You can sell the house, refinance it, live in it, do whatever you want. Nothing changes in your daily life. But when you die, the house transfers to your named beneficiaries without going through probate. No court process, no public record, no 6 to 24-month wait. And you can put very specific instructions in the trust about what happens to the property. What if one heir wants to sell and another doesn't? Address it in the trust. Who manages the process? Name that person now. The trust also preserves the stepped-up basis because the property is still considered yours for tax purposes during your lifetime. Your children get the step up when they inherit. Tax efficiency maintained. The second tool is the Transfer on Death Deed, often called a TOD deed or beneficiary deed, available in many states. You record a deed naming who inherits the property at your death, similar to naming a beneficiary on a life insurance policy. The named beneficiary has no rights while you're alive. None. They can't sell it, can't mortgage it, can't create complications. You retain full ownership and control. When you die, the property transfers by operation of law, completely outside of probate. Check whether your state offers this option. The third tool, state-specific but powerful, is the Ladybird Deed or Enhanced Life Estate Deed, used in states including Florida, Michigan, and Texas. It is generally protected from Medicaid estate recovery. If Medicaid planning is a concern, ask an elder law attorney specifically about this. Here is what I want you to take from all of this. Not anxiety, not overwhelm, just intention. David and I have a trust. Our home is in it. Jennifer and Michael know exactly what will happen. There is no question. There is no ambiguity. No one will have to go to court. No one will have to guess what we wanted. And that peace of mind, I cannot put a dollar figure on it. I know what it looks like when there is no plan. I watched it for 24 years. You can always make more money. You cannot make more time. And you cannot unfracture a family once the legal battle starts. So please, if nothing else from today, make one phone call. Make an appointment with an estate planning attorney. Ask specifically about trusts, transfer on death deeds, and Medicaid planning if relevant to your state and situation. A few hours of planning now can save your family years of heartache and tens of thousands of dollars in avoidable costs. That is not an exaggeration. That is what I watched happen to real families, real people, over and over again. Please take care of this while you have the clarity and the time and the health to do it right. The families who planned ahead, who had these conversations, who put the right structures in place, those were the families who could grieve in peace, who didn't have to argue in a courthouse while still processing the loss of someone they loved. That is the legacy worth leaving, not just the house, the peace that comes with it. This is educational content and not legal or financial advice. Every state has different laws and every family has different circumstances. Please work with a professional who knows your specific situation. Thank you for being here with me today. Don't waste the youth of your senior years, and please, don't let this wait.